I disapprove of what you say, but I will defend to the death your right to say it. This quote has been the cry of free speech advocates for decades. But how is society to treat those, especially minors, who violate the standards of speech considered acceptable in public? In the case of Mahanoy Area School District v. BL, the question is, what are the legitimate actions of public schools in disciplining the vulgar speech of students? In its opinion, the Supreme Court illegitimately applied the First Amendment to state actors, but that's nothing new. By far the most interesting part of the opinion is the role the justices believe schools have in parenting children. And you may be surprised by what the lone dissenter in this case had to say regarding the subject. So we'll discuss this next on the Constitution Study.
You have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Welcome to the Constitution Study. I am glad you could join me. As always, please head to the website constitutionstudy.com for more information about the study, about how you can share the information, how you can participate, how you yourself can become a better student of the Constitution. Speaking of students of the Constitution, head to constitutionscholars.com for information about how you can become a scholar. It doesn't take a law degree. It doesn't take years of study. Really, a scholar is just a student. So the Constitution Scholars are where students get together to read and study and discuss the Constitution amongst ourselves without worrying about, we'll just say certain companies putting algorithms and limiting our speech. So you can find all that and more at those two websites. And let's now talk about this decision about speech. I don't know about you, but I find vulgar language revolting, especially from the mouth of a young lady. While there was a time in this country when such language was frowned upon, it's much more accepted now. Which brings us to the case of Mahanoy Area School District v. BL, who as a minor was represented by her parents. Now, according to the opinion syllabus, BL failed to make the school's varsity cheerleading squad and reacted by posting vulgar language and gestures on Snapchat. When school officials learned of the post, they suspended BL from the junior varsity squad. After unsuccessfully attempting to reverse the punishment, BL and her parents sought relief in federal court. It seems like I say this a lot, but it's worth repeating. This cannot be a First Amendment violation because Congress had no part in the law. The First Amendment says, quote, Congress shall make no law abridging the freedom of speech. If what the school did was a violation of BL's freedom of speech, then it was a violation of Article 1, Section 7 of Pennsylvania's Constitution, which reads, quote, the free communication of thoughts and opinions is one of the invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty. Since BL did not sue in state court, but in federal, many people, especially lawyers and judges, claim the 14th Amendment incorporates the First Amendment to the states. However, that's not what the amendment says. Quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. Since freedom of speech is protected from state intervention by the constitutions of that state, not the Constitution of the United States, the 14th Amendment doesn't make this a First Amendment issue. At best, had the Commonwealth of Pennsylvania denied BL the privileges or immunities of others within her state, well, then she would have had a 14th Amendment cause, not a First Amendment one. Now, continuing from the court's opinion, quote, BL Snapchat friends included other Mahanoy area school students, some of whom also belonged to the cheerleading squad. At least one of them, using a separate cell phone, took pictures of BL's post and shared them with other members of the cheerleading squad. One of the students who received these photos showed them to her mother, who was a cheerleading squad coach, and the images spread. That week, several cheerleaders and other students approached the cheerleading coaches, visibly upset by BL's posts. Questions about the post persisted during an algebra class taught by one of the two coaches. Apparently, BL's post went to some of the cheerleaders, one of whom showed them to her mother, who happened to be a cheerleading coach. And as the post spread, several students were upset by them, and they approached the coaching staff. In fact, questions about the post persisted during an algebra class taught by one of the coaches. Quote, After discussing the matter with the school principal, the coaches decided that because the post used profanity in connection with a school extracurricular activity, they violated team and school rules. As a result, the coaches suspended BL from the junior varsity cheerleading squad for the upcoming year. BL's subsequent apologies did not move school officials. The school's athletic director, principal, superintendent, and school board all affirmed BL's suspension from the team. In response, BL, together with her parents, filed this lawsuit in federal district court. The question that should have been asked at this time was, is vulgarity considered abuse of freedom of speech in Pennsylvania? Instead, the parents filed a lawsuit in federal court. Now, the district court and the Third Circuit claimed that BL's punishment violated the First Amendment, an opinion I've already debunked. All this was done based on the decision of a previous court in the case of Tinker versus Des Moines Independent School District. The Mahanoy Area School District petitioned the Supreme Court asking it to decide whether Tinker, which holds that public school officials may regulate speech that would materially and substantially disrupt the work and discipline of the school, applies to student speech that occurs off campus. Now, the court held that, quote, while public schools may have a special interest in regulating some off-campus student speech, the special interests offered by the school are not sufficient to overcome BL's interest in free expression in this case. The court explained the Tinker opinion as follows, quote, in Tinker, we indicated that schools have a special interest in regulating on-campus speech that materially disrupts classwork or involves substantial disorder or invasion of the rights of others. The special characteristics that give school additional license to regulate student speech do not always disappear when that speech takes place off campus. Circumstances that may implicate a school's regulatory interests include serious or severe bullying or harassment targeting particular individuals, threats aimed at teachers or other students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other online school activities, and breaches of school security devices. Notice the language. In Tinker, we indicated that schools have a special interest in regulating on-campus student speech. In other words, it was not the Constitution or the law that granted schools the power to regulate speech, but the Supreme Court. This in itself is a violation of the Constitution, since the judicial power of the United States does not include the legislative or lawmaking power. Are there situations when a school needs the authority to regulate student speech? Yes. Speech that includes bullying, harassment, or other threats are not covered under free speech because it infringes on the rights of others. Now, as the Commonwealth of Pennsylvania puts it, that would be an abuse of that liberty. See, it's not within the power of the courts to delegate that power. Neither is it within the power of the court to take a state free speech issue and make it a federal one. So by doing so, the court has taken the regulation of student speech to a whole new level. The court does this using a doctrine called in loco parentis, which the Free Legal Dictionary defines as, quote, Latin for in place of the parent, the legal doctrine under which an individual assumes parental rights, duties, and obligations without going through the formalities of legal adoption. See, it's important to understand the concept of in loco parentis. There are times when your children are in the care of others. During those times, the law recognizes that some parental rights are assumed by the caretakers, though that brings up a couple of interesting questions. First, what are the limitations of in loco parentis rights? Do the caretakers truly assume parental rights, or are they merely delegated a limited number of rights while the children are in their charge? Second, does government have the authority to assume in loco parentis and act against the will of the parents? Since governments have passed laws that require that your children go to school, does that mean the government can transfer your rights as a parent to the school? And if so, what are the limitations of the rights transferred? In the past, it was recognized that a school acting in loco parentis was limited to maintaining the safety of the student in a working educational environment. So a school could discipline a student for fighting or disrupting class, but could not administer medication or authorize medical procedures except in the case where the student was in imminent threat of death or serious bodily harm. However, that view has changed. See, I remember as a child having to take some medication while at school. I had to take the medicine to the school nurse along with a note from my parents. I was required to go to the nurse's office and take the medicine in front of her. I could not even get an aspirin without the nurse contacting one of my parents for permission. Today, we have reports of schools taking children for elective treatments, not only without their parents' permission, but without their knowledge. So this concept of in loco parentis seems to have morphed from a limited power to protect the student to an overruling of parental rights at the sole discretion of the school district. Now let's discuss the court's opinion on this off-campus speech. Quote, "But three features of off-campus speech often, even if not always, distinguish school efforts to regulate off-campus speech. First, a school will rarely stand in loco parentis when a student speaks off-campus." Okay, according to the court, a school rarely acts as a parent when the student is off campus. Think of the permission slips we needed our parents to sign before we could go on a field trip. They authorized the school to act in loco parentis while off campus. Today, while the court says schools rarely stand in loco parentis when a student is off campus, they're about to contradict themselves. Quote, "Second, from the student speaker's perspective, regulation of off-campus speech, when coupled with the regulation of on-campus speech, include all the speech a student utters during the full 24-hour day. That means courts must be more skeptical of a school's effort to regulate off-campus speech, for doing so may mean the students cannot engage in that kind of speech at all." If the school can regulate off-campus speech, then they're acting in loco parentis 24 hours a day, 7 days a week. Notice that the opinion states that courts must be much more skeptical of a school's efforts to regulate off-campus speech. Not that the school doesn't have the authority to regulate off-campus speech, even with limited exceptions. This isn't in loco parentis, but pro parentibus, replacing the parents. Quote, "Third, the school itself has an interest in protecting a student's unpopular expression, especially when the expression takes place off campus, because America's public schools are the nurseries of democracy." Public schools don't have an interest in protecting student speech. They have a duty. Schools are institutions of instruction, not nurseries of democracy. Perhaps if the schools these justices went to had spent more time instructing them and less time considering what was in the school's best interest, these men and women would realize not only that America is not a democracy, but that our founding fathers feared that it would become one. As James Madison said, quote, "Hence it is that such democracies have ever been spectacles of turbulence and contention, have ever been incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths." Now, for those of you who view Justice Thomas as a conservative, well, this dissent may leave you sadly disappointed. Quote, "When students are on campus, the majority says, schools have the authority in loco parentis, that is, as substitutes of parents, to discipline speech and conduct. Off campus, the authority of schools is somewhat less. At that level, I generally agree, but the majority omits important detail. What authority does a school have when it operates in loco parentis? How much less authority do schools have over off-campus speech and conduct? And how does a court decide if speech is on or off campus? Indeed, what authority does a school have off campus? Are our children property of the state? Does the state have the first word on conduct and behavior of our children 24 hours a day, 7 days a week? Quote, "A more searching review reveals that schools historically could discipline students in circumstances like those presented here. Because the majority does not attempt to explain why we should not apply this historical rule and does not attempt to tether its approach to anything stable, I respectively dissent." Once again, Justice Thomas places the opinion of other courts above the rule of law. He didn't dissent because the First Amendment specifically limits Congress or because there is no language in the 14th Amendment to expand that to the states. His argument is that historically, courts have allowed schools to punish students for their off-campus speech. He then goes on to cite examples of state court opinions that state, quote, "A school can regulate speech when it occurs off campus so long as it has proximate tendency to harm the school, its faculty or students or its programs." This is from Lander versus Seaver in 1859. Justice Thomas then goes on to claim that BL speech had a direct and imminent tendency to subvert the cheerleading coach's authority. Well, if that's the case, then any disagreement with a teacher or school policy could be regulated as subverting the school's authority. So much for free speech. Now, if BL were my daughter, I would have handled the situation very differently. However, she's not my daughter, so I have no authority to punish her for her actions. And if I cannot do so individually, how can I delegate that authority to a government agent? The question that never seemed to be asked was, does the school have the authority to regulate who participates in school activities, including what qualifications are required? I loathe the idea of government actors regulating the speech of others. However, as the Pennsylvania Constitution notes, we are all responsible for the abusive use of our liberties. We can all speak as we wish, but we are also responsible for the consequences of that speech. When I worked for a corporation, I could be fired for language that was derogatory to that company. In the same vein, BL does not have a right to be a cheerleader. If her actions are derogatory of the school and its extracurricular activities, there should be consequences for that. If BL has shown a tendency to fly off the handle for a decision she disagrees with, what would happen if she disagreed with a referee's call during a game? Could another profanity-laced incident happen out in public? I believe her parents have done BL a disservice. See, rather than taking the opportunity to learn from her mistake and find a way to make amends, they have taught her that the proper response to not getting what she wants is to sue all the way up to the Supreme Court. As for the court, it once again claimed the authority to be above the law. It ignored the language of the First and 14th Amendments in favor of a prior court's interpretation. They ignored the jurisdictional issue, giving future courts another nail in the coffin of judicial supremacy with which to seal our liberties away forever. And while claiming that schools' power of in loco parentis is limited, their actions show that they believe the schools are superior to parents in most situations. Now, whether you agree that BL should have been suspended from cheerleading squad or not, ask yourself these questions. Who are the parents? The real parents or the school? Should there be no consequences for behavior that denigrate a school's activity? And lastly, what is the emotional outburst that should be punished, or the language that should be used? You know, it's funny, when I first heard of this case, my first thought was, you know what, there's language that I'm for free speech. I don't like government regulating language. But then as I learned more about it, I realized it's not simply about regulating language. It's about what are the consequences for that language. Does the school have the authority to say our cheerleaders must conduct themselves in certain ways? Now you may ask, but what does the Constitution say about this? Well, think of it this way. Article 3 of the Constitution says that federal judges serve during their good behavior. Now, early in the Republic, do you know the judges were actually impeached for being intoxicated while off duty? See, there was concern that a judge that was caught intoxicated and possibly could be compromised and then leveraged, even blackmailed, to pervert their opinion. Now, I'm not saying a cheerleader has anywhere near that type of power. But again, if you are running an organization and somebody speaks derogatorily about it, whether they use vulgar language or not, I'm less likely to want that person on that team. And that's true in professional sports, right? What, you know, is it right for football teams to decide, you know what, if you're not going to stand for the national anthem, you're not going to play? Is it right for teams to require certain uniforms and conduct? You know, it's a bit bigger picture. So I'm not real strong on one side or the other. So on one side, I say, wait a second, free speech is free speech. And I agree, BL should be able to say whatever she wants. I don't think the school has the authority to tell her what she can and cannot say. However, she is not absolved of the responsibility of those words. And that's where I think the real harm comes. It's not that that BL used bad language and that apparently wasn't punished. It's not even whether or not she plays on the varsity team or the junior varsity cheerleading squad. Now, to me, the real problem is, what have we taught her? Again, her parents taught her that if you don't get your way, sue all the way up to the Supreme Court. If you know, I'm sorry is not good enough, sue. I mean, she did apologize. She did go back and apologize for those words. It wasn't enough for the school. But her parents have taught her, then just sue everybody. You wonder why we have more lawyers and doctors in this country? It's stuff like this. But on the other hand, I look at the court, and what did the court do? The court looked at this, and they ignored the Constitution, they ignored the rule of law, they came up with their own opinion out of thin air. They became the super legislature. They set the rules without anybody having oversight over them. And that's even more dangerous. Now, all in all, this is a really bad decision with really bad facts, really bad circumstances. And I think, again, we've lost something. We've lost that understanding that, yes, freedom of speech means you can say what you want, but it doesn't absolve you from the consequences. If you lie in court, you can be charged with perjury. If you defame someone, you can be sued for that. That doesn't change. Sadly, what the parents and the courts have taught BL is that she can defame anyone she wants, and there are no consequences. All she's got to do is sue. So I hope this analysis helped you a little bit. Kind of look at it in more than one, flat view, like most of the accounts that I've heard about this. If you want more like this, please head to constitutionstudy.com. If you're listening to me on a podcast, hey, go to Apple Podcasts, give me a rating and review, help other people find the Constitution Study. Take the video, the audio, the article. They're all available for you on the website, constitutionstudy.com. Please share them. Everything I do on Constitution Study is absolutely free for you to use and for you to share. And I encourage it. Now, if you can help me support that work, well, there's a donation form on the website. Just go to constitutionstudy.com/donations. You can support the website itself. You can support the tours that I'm going on, any other projects, they're all there. And all that support, I truly appreciate. I'm not making any money from this. This is all about helping me get this information out to more and more people. The more money I have, the more ways I can share this information. Now, also, if you would, check out constitutionscholars.com. This is a site where scholars get together. You sign up, it's absolutely free to register. You get access to all the community groups that are public, right? So there's a community group for the U.S. Constitution. There's a community group for each of the states. I've had people ask me about setting up groups for different special interests. I'd be more than willing to do that. There's enough interest. Now, there is an apprentice program where you can become mentored into becoming a more self-sufficient and being able to teach others. You can check that out there as well. But the idea is this is a place where we can read and study the Constitution without algorithms getting in the way. Now, since this is now August, the first leg of the Knowing Your Rights tour is about to kick off. I'm going to be in Grand Forks, Killdeer, and Bismarck, North Dakota. I'm also going to be in Thermopolis and Douglas, Wyoming. Now, if you're anywhere near those, or you just want to find more information, go to Constitution Study/tour. If you're near those locations, I would love to meet you. If you can't come to the event, well, let me know. Maybe we can squeeze something else in while I'm there. Now, if you're not from that area, well, just go to the bottom of that page, that tour page, and you'll see a form. See if I can come out to visit you and your group. It doesn't have to be a big event. It can be a group of people in a restaurant, or I'm meeting a group of people in a bakery. But it's an opportunity for you to get together and we can study our rights, know what our rights are, recognize when they're being violated, and prepare ourselves to defend and assert them. And now more than ever, those are critical tools that we are not taught, that we need to teach ourselves. So again, find all the information you want at constitutionstudy.com/tour and share all this material, because that's how we protect liberty and freedom in America, is by educating ourselves and educating our family and helping our neighbors educate themselves as well. So please share that, and please come back and join me here next time at the Constitution Study.
There's one thing you have to